Hello. Welcome to our last chapter for the semester, chapter 13. We'll be talking about adoptions today. For the most part, adoptions are a happy subject. Adoptions are always a very happy kind of case for me to handle. I always look forward to doing them. Adoptions, for the most part, are always a chance to work with families on an exciting new chapter in their history. And so it's always a good thing for me. It's always a time for smiles and pictures, and usually there's a cake involved or cookies, and it's new memories are made, and I always look forward to it. And so let's talk about what some of the laws are with regard to adoptions, and how adoptions are done. So before we get started, though, there were a couple of questions with regard to the Family Law Project, and let me make sure that those are taken care of. Last week I told you that what I wanted you to do is to brief or summarize legally the case of Stone versus Gulf American Fire and Casualty Company. And the site for that case is 554 Southern 2nd, 346. And that is, and I don't know if I gave the date for it or not. It was decided July 5th, 1989. And I believe I told you that it involved the family of Hank Williams. Hank Williams, and then Hank Williams Jr., and Hank Williams' daughter that he gave up for adoption, Jet Williams. And and let me just reiterate my expectations for that. It's called a brief. You are briefing a case, and it's a way to summarize the case in a legal fashion, to get down to what the legal findings of a case are for a supervising attorney. What I will expect, and what a supervising attorney in the future will expect from you, from a case that you found, will be the title of the case, the legal history of the case, meaning what all courts has the case been through, the courts, and the dates of the decisions, of the dates of the decisions of those courts, and then a summary of the facts, and then a summary of the legal a summary of the legal the legal issues that are discussed in the case, and then the legal findings that are made in the case. And then also in the end, if there is a meaty dissent in the case, and there is one in this case, please summarize that as well. It's, in some cases it's legitimate enough that it warrants, a mention. And in this case, it certainly does. So, do a little summary on that as well. And then finally, never turn a case over without shepherdizing it. And in this case, um, be sure and note, every subsequent decision that this case has gone through. So that will be due by next week. And, let's just say we're going to have our exam on the 4th. I'm going to post the exam on the 4th. And it will be, I will make the exam available I'll make the exam available on the 4th, at our regular time at 5:30, and it will be available I'll make the exam available by 5:30 on the 4th, and then I will go ahead and it will be available until 8 o'clock. So that'll be 2.5 hours. And then let's go ahead and say that the Family Law Project will be due by the 8th. No, yeah, the 8th. And everyone must have theirs in to me by course message on the 8th. And that'll still give me time to get everything graded and have my final grades in time. And that'll give you a few extra days. Okay? I just feel like I don't really know how everything is going with y'all. I'm able to track your views of these videos by YouTube, but I don't really know how everything is going with you individually. I hope everything's going okay. I know that everybody's situation is different, and I'm trying to allow for that. So, okay. Let's talk about adoption. So, adoption really does two things. It allows for the creation of new family relationships. It makes a new family of a family that makes new family relationships of relationships that were not in existence before. It creates a new legal family relationship. At the same time, it legally severs what was a biological family relationship. It forever extinguishes a biological family relationship. So where a father, for instance, a father and a child were biologically joined, when that child is adopted by, say, a step parent, that father and that child are forever ever severed from one another. That father is as if he never was that child's parent. And now that step parent is officially that child's parent, just as if he was always that child's biological parent. I understand that there are heart issues involved that can make it feel different, but legally it's as if he always was that child's parent. He always was and always will be that child's parent. So it severs some and creates new at the same time. So adoption laws have their root in Roman law. Um, in our family law chapters, in our family law, we've always gone back to English common law. We've always talked about our history being in either in English common law or in American colonial law or American colonial history. But in adoption law started off in Roman law and culture because of um, it was for the benefit of not the adopted child. We're used to talking about things being for the benefit of the child or the best interest of the child. But in Roman culture, the idea of the adoption was for the benefit of the adopting family, a family that was approaching the end of a bloodline would be allowed to adopt a male child in order to save the family from the extinction of its bloodline. Or our textbook gives us the example of Julius Caesar being allowed to adopt his nephew so that he could actually choose him as his successor. He was allowed to handpick him as his successor by adopting him. Unlike that, English common law did not allow for adoption. In English common law, they had such an emphasis on blood lineage, that if it wasn't biological, they did not allow for it, that they thought it was incompatible with this idea of blood lineage, so they did not allow it. And however, even though they didn't allow for adoption in English culture, many of the English children were spent portions of their childhood living with other families outside their family of origin as servants or apprentices. And then in America, children of the colonists were also sent to live with other families as servants or apprentices. And this idea of apprenticeship, apprentices were under a formal arrangement by which a child was indentured or under a formal arrangement, pretty much like a slave. Although they didn't call it that. The child didn't have any choice, really. But it was a middle to upper class arrangement. And the child was supposed to be taught a trade and then in return provided with a place to live. So the child was supposed to give their labor, and then in return they were given room and board and to be taught a trade. And the adult was supposed to act in loco parentis, or in place of a parent, in the place of a parent. And in other words, taking on all rights and responsibilities of a parent. So I don't know, to me it sounds kind of hypocritical that they would shun the practice of adoption because it wasn't blood, it wasn't like it wasn't natural. But at the same time, they would have these formal indentureships where they would send a kid to live with this other family and grow up with this other family and let this other adult treat them like their child during all their formative years so they could teach them a trade. And who knows how much teaching was involved. Um, so at the same time, you have the poorer families having I guess, um, a somewhat similar arrangement. But you would have that in more of a situation where the situation where parents couldn't provide for their children. So it wouldn't be where parents would work it out with someone who would teach their kids a trade and they would work out an agreement with another person, but it would be more where a parent couldn't take care of their child, and so the officials would take the child and put it with somebody else. So you can see that the precursor to the DHR pickup of a child and placing with foster parents. That would be, the precursor to that. So in 1851, Massachusetts was the first to pass an adoption law. And in that very first adoption law, Massachusetts placed adoption under judicial control and made clear that adoption was intended to benefit the child, not the adoptive family as it was under Roman law, but it was to benefit the child who needed a home. And that before the child was to be adopted, under this groundbreaking Massachusetts law, the family had to first be scrutinized to ensure that they had the ability to bring up a child and that the family was fit and proper before the adoption could take effect. And that after the court approved the adoption, so you have court approval then coming into the picture. After the court approved the adoption, the child would then become the legal child of the adoptive family, parents, and then the bond between the child and the biological parents would be severed. So this Massachusetts law in 1851 pretty much sets up what we have now as our adoptive framework. That we have to look out for the best interests of the child, that the adoptive family must be scrutinized to make sure that they are fit and proper before adoption can take place, that a court must approve an adoption before it can go forward, before it can be finalized, and that once an adoption is approved, that the bond between the child and its biological parent is forever severed. And all those things are still true. So that's pretty remarkable, I think. All right, so page 645, there are two basically different paths to adoption. One is what we call independent adoption, and that means independent of DHR. And then the other is one that comes through the dependency route through DHR, and like we talked about in chapter 12. An independent adoption can go through an adoption agency, Um, we can, it may be a situation where a parent has a child and they have signed a voluntary relinquishment of parental rights. Um, there must be or consent. There must be consent by the parents to adoption, and we can talk about that a little more down the road. There must be consent of some sort, of some particular kind, to the adoption by the parents. Um, Now, if you do go through, if adoptive parents decide to go the independent route, in other words, not through DHR, where DHR has parents who have not been able to take care of their child, and the child has been adjudicated dependent, and then DHR has moved to terminate the parental rights, and then there's a family that wants to adopt that child. If you're not going that route, and instead, you've looked for if you've looked for a child of someone who just who wants to voluntarily relinquish their parental rights, independent of that process, then at the bottom of page 647, one concern I think that states have had to be careful about is working with mothers who are pregnant. When adoptive parents have identified a pregnant mother who wants to give her baby up for adoption, states have had to be careful about making sure that parents are not paying mothers to give up their children. In other words, baby buying. You cannot pay so much money to a mother who's pregnant that you are in essence paying for her baby. In other words, you are paying so much money that it is an inducement, or it is you are coercing her to give up her baby. That is against the law. You can help her in her pregnancy. You can aid her, but you have to be careful. I mean, there's a line there. In Alabama, if you are guilty of baby buying, it is a Class A misdemeanor, which is where you can be sentenced to up to a year in jail. If you are guilty of selling your baby, it is a Class C misdemeanor, which is up to 30 days in jail, which, if you think about it, really is not that stiff, considering I don't know. You've probably had as much experience as I have around people who want to have children and can't. I I have so many friends who have tried and tried to have children and can't, and just there are several of them just have just been at their wits' end. And then I show up to a paternity docket in court, where people are owe child support, or there is a parent who says the other parent is either owes support or needs to start support or owes back support, or either is a parent and needs to be adjudicated a parent. Deadbeat dad dockets. And I look out and it's full of people who maybe are parents, and some of them don't want to be parents. And sometimes to me, I don't know. Sometimes it doesn't seem just. And so, when the fact that baby buying and baby selling, I don't know. It doesn't seem like it's that big of a penalty for baby buying and baby selling. So you've probably heard of in your book what's called safe haven laws. These are laws that protect parents who find themselves in situations where they feel compelled to drop their baby off in a public place when they feel like they can't take care of a newborn baby. Um, Texas in 1999 was the first state to have one of these laws. Your book says they're sometimes referred to as baby Moses laws. And that's because, of course, in the Old Testament, Pharaoh said that, all firstborn male child were to be killed. And baby Moses, was put in the basket and set out in the river and was saved that way. And so all states have different laws about how this can or shall be done, and under what circumstances it's legal to do that. Obviously, last week I talked about the difference between law and public policy. So the public policy is that we want to give people who are struggling with a situation, who have just given birth, but are in that postpartum, just having given birth, or in that postpartum mindset, freaking out, don't know what to do. We want to give them a window of time where they can do the right thing. If they can't do the baby thing for whatever reason. Maybe you're 15 years old and you can't tell your parents, or maybe you're whatever your circumstances. We want to give the public policy, the big picture idea is that we want to give people a safe option to handle that situation. The legal issue is, how do we structure it so that it is a window small enough and defined enough so that it's not out of hand. It's definable, and so that we know what to expect. So in Alabama, without a court order or anything, you don't have to seek the court's approval or anything. A parent may deliver a child within 72 hours of birth or younger to a medical service provider. If they did not express an intent to return. And if they did not express an intent to return, then that baby is deemed to have been delivered under the safe haven law. And that baby will then be delivered into the custody of the Department of Human Resources. It will be deemed to have been abandoned. And by medical service provider, we're talking about an emergency room. And that's pretty much the only place that you can abandon a child legally in Alabama. Fire stations, police stations, churches, no. In Alabama, no. Emergency rooms. Because medical service provider. So, and it has to be within 72 hours of birth by a parent. So, also, I mean, there are basically and there are basically two goals here. One, you want to protect the parental anonymity. The public policy is there to allow them to address their emergency situation, whatever it is. Whatever the reason it is that you are in this mindset that you feel like you cannot do this, we want to allow you to protect your anonymity. Also, we want to allow you the 72 hours of immunity from prosecution for abandonment or neglect. Okay. So let's talk about the adoption process. Adoption can take place only if the rights have been involuntarily terminated, or there has been consent of the parents. In some states, consent of the child is required. In Alabama, if the child is 14 or older, the consent of the child is necessary. And you can see why this would be important. once a child is 14 or older, arguably even younger, but legally 14 or older, a child is going to be a very active participant in any domestic situation. I mean, you can see, even in a divorce situation, if you were talking about custody, a child is going to be able to take part in any decision about where they should live, or who would be um, a visitation, custody, anything like that. I mean, they're going to be able to to give some very good information in that situation. And adoption is no less so. They're going to be able to they are going to be able to participate in a very active way. And if they don't feel like that if they don't feel like that an adoption should take place, an adoption over their objection is probably not going to be a good thing. This is a teenager that we're talking about, so any consent from them is going to be necessary, legally and policy wise. So, what about parental consent? Parental consent is an essential requirement in a private placement adoption. To be valid, consent must be fully informed and free from duress, fraud, or undue influence. And it must be in writing and signed before a public official. If contested, it might be hard to prove sometimes that it was not free, that it was free from duress. How can you prove that a 14-year-old, or that a young mother gave up her baby voluntarily, for instance? When she had her parents hovering over her. That might be kind of hard. I mean, you can imagine sometimes the pressure that might be brought to bear in that situation. So in Alabama, a mother's consent may be withdrawn 5 days after birth, or 5 days after signing the consent, whichever comes last. If there is a court order, if you go to a court and ask that your consent be withdrawn, then it can be withdrawn if the court finds that it's reasonable under the circumstances that your consent be withdrawn. That it is consistent with the best interest of the child. that it is within 14 days after the birth of the child, or that it's within 14 days after the signing of the consent. Now, if we're talking about reasons of fraud, duress, mistake, or undue influence, in situations, for instance, where somebody tricked a mother into signing a consent, or they told her things that were not true in order to get her to sign that, then she's going to have a year to withdraw her consent. So think about that. I realize that her rights are at stake, but think about the child. So the child goes to live with his or her adoptive family, and up to a year later, the mother comes back and says, that for reasons of fraud or duress, mistake, or undue influence, maybe because of her parents or some other undue influence, she was forced into making this decision, and she gets a court to allow her to withdraw her consent. And so the child is then yanked back out of the adoptive family. I mean, you can imagine how hard that could be on an adoptive child already taken away from a biological parental situation and put with an adoptive family, only to be taken back from the adoptive family and put back with the biological parent. So this can be traumatic for a child. So what if we're not talking about voluntary consent? No, we're not talking about a parent who gives their consent and then either allows the consent to go through or then withdraws their consent. We're talking about a parent who doesn't take care of their child, and then DHR steps in and then the child is adjudicated dependent, and then DHR looks to terminate the rights of the parent. So that's going to be, that's going to be, instead of being an independent adoption, that's going to be more a DHR track adoption. So what about that? If the rights of the parent have been involuntarily terminated because of abuse or neglect, then adoption can proceed without their consent. And, there's a lot less risk in that situation because, the parents have been divested of their say in the situation. However, DHR has to start moving towards adoption usually before actually terminating the parent's rights. So usually what happens is DHR usually pursues dependency of a child. We talked about that in chapter 12. And then once a child is adjudicated dependent and perhaps goes into foster care, then after a period of time, the child might be placed with what's called an adoptive resource, a family who is, yes, they are a foster care family, but also it may be a family who wants to adopt the child. Your book calls them an at-risk placement, and I want to look this up on my photos because I looked this up in the Administrative Code, Department of Human Resources Administrative Code. Um, they call it a legal risk placement. Placement of a child with a prospective adoptive resource on a foster care basis pending legal proceedings to terminate parental rights or during appeal proceedings of a court order terminating parental rights. In some situations, infants may be placed with prospective adoptive families directly from the hospital on a legal risk foster care basis. Let's see. Okay, so the child is placed with this at-risk adoptive family, foster care family. And so they get to start cultivating those relationships while DHR files a termination proceeding with the court and pursues terminating the parental rights. So there is risk involved in that. And DHR is gambling on the fact that they will be able to terminate those parents' rights. And the adoptive foster care family is gambling on the fact that those parental rights will be terminated. And if the termination proceeding is successful, then those parents' rights will be terminated, and the adoptive family will be able to proceed in probate court with adoption proceedings to adopt that child. Okay, so in the DHR realm, adoption realm, kids who have had their parents' rights terminated, there are a lot of kids who are up for adoption. And many of those children have been in the protective services system for a while. And many of them have experienced some level of abuse or neglect. I mean, that's why those children were taken away from their parents in the first place by DHR. Few of them are the perfect baby, that biologically people would have on their own. And some have lived in a variety of foster homes, and and nobody knows what they experienced in those foster homes with those other children who also had their own experiences. So, and there are different ages and different ethnicities and all kinds of different backgrounds. So when a family goes into the adoption process through DHR, it's important to go in with an open mind. That you're not going in, if you're going to go in through DHR for adoption, it's important to broaden your scope. The child that you might be able to adopt may not be a baby, may not be two. So you need to, if you want to adopt through DHR, it may be important to say, okay, that's okay, but maybe no older than 5. And and just and be open as far as uh, background, ethnicity, you know, and other things, because you don't ever know what kind of children are out there. And like, I know that my law partner had a kid who was 14 and whose parental rights were just terminated, and he needs an adoptive home, and he doesn't want anything else except somebody to love him. And my partner is just committed to the hope that somebody is out there for him. And yeah, I mean, there's only 5 years between 14 and 19 when he ages out of the system, but those 5 years are important. And somebody's going to come along who wants those 5 years with him. So that's the difference between independent adoption and DHR adoption. Maybe the difference is in the expectations of the people who come into the process. All right, so page 653. Before an adoption can go forward in Alabama, a home study is required. And a home study is intended to weed out inappropriate or unsuitable parents or homes. And an agency, like DHR or a licensed agency, cannot place a child until a home study's been completed. So during a home study, they usually ask prospective parents about a variety of things, and your book gives a list of things, and this is not a bad list. A friend of mine has just recently gone through a home study for an adoption, and based on what they shared with me, this is not a bad list. Religious beliefs and practices, yeah, they do get pretty personal. Approaches to child rearing and discipline, obviously, that's going to hit really close to home, yes. Child rearing skills, the nature of relationships with extended family members, yes. They ask you about how do you get along with your parents, how do your parents get along with you. The nature, history of prior intimate relationships, yes. Career plans and how the child will be cared for. What do you plan? Do you plan to work? If you get a child, or if you adopt a child, do you plan to work? Where do you plan to work, at home or at work? What's your schedule going to be like? Ability to provide for the child financially, that's obvious. History of criminal convictions, emotional stability and maturity. They want to know about your marriage. They want to know about your prior emotional relationships. They come to your home. They want to look all over your home. They want to know about your pets. They fingerprint you. They want a physical checkup. It's not like they get like a history of your medical records back when you were 4 or anything, but it's pretty personal. And frankly, shouldn't it be? if they're looking to place a child with you, I think it should be pretty personal. Um, so yeah, a friend of mine just recently went through this, and this is pretty accurate. Um, and your book says, I mean, if you don't already have a biological connection with a child, um, it's thought that prospective parents need to be evaluated to determine their capacity for developing a loving, responsible relationship with a child. The criticism of this is that it's a thinly disguised effort to determine how closely you conform to the idealized version of the perfect family. The Ward and June Cleaver, or let's see, that was in my generation. Um, the white bread family, perfect family. Are you that or not? The other criticism is that it's a bias against adoptive families. That biological families are not. And I don't know how valid this is really, because you have to evaluate potential adoptive families in some way to protect potential adoptees. I mean, to me, that's just true. You have to protect children. And so, critics who say that, well, you don't evaluate biological parents, why are you doing this, this home study to evaluate potential adoptive parents? Well, because, before we just throw a child into a home, we're going to see if it's in their best interest, if this is a suitable home or not. We have to protect children. So I don't really see, I don't really think that it's a valid criticism to say that, we don't evaluate biological parents this way. Why do we evaluate potential adoptive parents? Because, because we have a chance to protect children, so we're going to take it. And like I said, it's not as if, we go back to the cradle with people before we let them have children. I mean, although it's thorough, I wouldn't say that it's, overly so. So, excuse me. So with private placement adoptions, usually parental rights are not terminated until the adoption is approved by the court. Although this makes it a little riskier than going through DHR, because with DHR, termination occurs and then adoption. We were talking earlier about that process. Usually, a child is removed from a home that's unsafe and placed with a foster family. And then if that family continues to be unsuitable, then DHR will seek termination. Termination will be achieved. Then that family can seek to adopt after termination is achieved. So in agency adoptions, like DHR agency adoptions, termination is achieved, then adoption is sought. And on page 655, you'll notice that it talks about post-placement studies. In Alabama, after the court orders an adoption final, there is a post-placement social study that is done as soon as possible, but at least 45 days after the adoption is final. All right. So let's on 656. Let's talk about adoption records. Historically, adoption records have been closed, and again, let's talk about the difference between public policy and law. Public policy historically has protected the biological parent who has given up the child for adoption. We wanted to encourage people who couldn't take care of their child to give the child up, so that the child could be cared for safely. And then in return, we protected their anonymity. And in order to do this, the records of the proceeding and along with the original birth certificate and new birth certificate, all of that was kept sealed. Well, the records of the proceeding, all of that, any kind of medical records, any of the names, all that was kept sealed. However, in the 1960s, that began to change because not because of the rights of the biological parent, but because I think society started to wonder if the secrecy was in the child's best interest. Not only because of the child's mental development, but also because of the stability of the adopted child's adopted family. Adult adopted children started to speak out about how damaging and confusing that confidentiality and that silence had been for them, and how they wanted to know more about their past and their biological origins, their family of origin. Eventually you started hearing about what's called open adoptions. Some states, open adoption offers a range of options after the adoption is final, offers a range of contact arrangements that can consist of anything from a yearly exchange of letters and photographs with no direct interaction between the child and the parent, to regular phone calls and regular visits and anything in between. A growing number of states have adopted open adoption laws that permit birth parents and adoptive parents to enter into judicially enforceable agreements regarding this post-adoption contact. They're called post-adoption contract agreements, PACA. And Alabama does not enforce them, but Alabama does have a statute that does provide for the provision of non-identifying information to children of a certain age. And we'll talk about that in a minute. Beginning in the 1970s, adult adoptees began to call for the opening of sealed birth adoption records. They brought several class action suits challenging the constitutionality of state laws requiring the sealing of adoption records. They argued that these laws violated their right to privacy, including a right to know one's identity and their right to equal protection of the law by continuing access to birth information upon one's adoptive status. So in Alabama, we have a statute that provides as follows. Non-identifying information shall be available to an adoptee when they reach the age of 19. And here is what constitutes non-identifying information. Birth name and adoptive name, date and place of birth of person adopted, except in the case of abandonment, circumstances under which the child came to be placed for adoption, physical and mental condition of the person adopted, insofar as this can be determined by the aid of competent medical authority, name and last known address of natural parents, dates of birth, and social security numbers, if known, age of the natural parents at child's birth, nationality, ethnic background, race, and religious preference of the natural parents, educational level of the natural parents, pre-adoptive brother-sister relationships, and whether the identity and location of the natural father is known or ascertainable. And these adoption records must be kept for a minimum term of 75 years by the Department of Human Resources. So, also, if the natural mother and father agree to the release of identifying information, meaning more information about themselves, if that's non-identifying information, identifying information, like more personal information, then DHR may release the identifying information that's been provided to them by the natural parents, may release that when the child is 19. And then one more provision, statutory provision in Alabama. If there is a compelling need for non-identifying information to an adoptee, then that information can be released. And under that statute, there's no age requirement provided. So, I guess, one reason I can think of that might come into play, is if there's some sort of emergency. Might require the release of that information at a younger age. That might constitute a compelling need for release of the information. All right, so 659. So many of the adoptions that take place each year are step-parent adoptions. And this occurs when a divorced custodial parent remarries. So a biological, let's say this is the example, a biological mother remarries. And the couple wishes to establish her husband as the father. They want to make a new family, and they want to make him the father of her child. Most states have kind of streamlined that process in some way. Alabama, for instance, doesn't require a home study in that situation. They don't require step-parent home studies. They still require Alabama still requires either consent or termination of a father or parent's parental rights, though. And this is because, adoption serves to sever a parent's biological relationship with a child. So before that can be done, before one can adopt, that parental relationship has to be severed, either by consent or by termination. So like I have a case right now, for instance, where a mother of a child wishes to terminate the father's parental rights so that her husband of 3 years can adopt the little boy, her little boy. And the father cannot be found. He's been in jail most of his life. And the father the last time he saw the little boy was about 5.5 years ago. And before that was probably around the time of his birth. And he's been in jail most of his life. And the last time anybody's been able to get in touch with him was earlier this year. He was finishing his sentence at a work release down south. And her lawyer was not able to find him for service of process, and ended up having to serve him by publication. So we have a hearing set, but because we served him by publication, I don't expect him to show up for the hearing. I imagine that we'll show up and for the termination hearing, and he will have been served by publication, but we'll show up and she will claim abandonment because he hasn't seen, talked to, or anything the kid in 5.5 years, and he hasn't provided a nickel of support. And she'll claim abandonment as her theory for termination of parental rights. And he won't show up, I don't think, tomorrow. And if the judge grants termination, then the stepfather, I'm sure, will proceed with a petition for adoption. And if he does, of course, being a step parent, the home study will not have to take place. But he will seek then to adopt the little boy, and he and the mother will then seek to make a new family. With him as the father. Okay. All right. So, single parent and joint adoptions. All states generally permit, single parent adoptions. All states permit that. However, as you can imagine, there is some bias when agencies are looking to place a child. There is some bias towards married couples. I know if we're thinking in a vacuum, we could say, why would that be? But, if we look at it strictly in terms of what's best for a child, and we have a functional, healthy marriage, then we have not one, but two people who are looking out for the best interests of the child, who are providing for a child, who are, responsible for the child. So we have two for the price of one. And I don't think that's that much of a stretch. As in my opinion, it's not up to me, but as long as they don't discriminate against single parents. As far as there is an Alabama Court of Appeals decision, however, that has ruled wait, I'm sorry. Excuse me. Let me back up. I'm sorry. So we talked about so let's talk about unwed fathers. What are the rights of unwed fathers? And what is, as far as what are their rights as far as adoption, consent for adoptions? What are their rights? Historically, many jurisdictions permitted the adoption of a child that was born to unmarried parents when the mother gave consent, regardless of the father. So, if you had a woman who gave consent and she wasn't married, then, if the father, if the father did, even if the father didn't want it, then the child could be adopted, which seems kind of barbaric nowadays. And the reasoning behind, that difference in treatment seems to be that, one, the mother's always there, whether she wants to be or not. I mean, she's there at the birth, right? I mean, the father could be a million miles away, but the mother really doesn't have any choice. I mean, she's there, right? And the second is that, this idea that, even at the time of birth, there's been this development of relationship between mother and child during pregnancy. That regardless of where the father has or hasn't been, the mother has carried the child all during pregnancy, and there's been this gestational time between the mother's body and the child's body and mind, where they have bonded. And finally, that that the different treatment between mothers and fathers could be based on the recognition that women can become pregnant against their will, and that they have to be vested with extra rights in that case to protect their safety. So states are all over the board as far as rights of putative fathers go. And some states are more conservative than others. And, it basically depends on which state you're in. So I just printed out our approach, and I want to take you through it real quick, because our approach is really what matters. Okay, so in Alabama, regardless of actual paternity, an adoptee's presumed father, which means an alleged or reputed father, shall be required, consent to adoption shall be required from a reputed father, for a presumed father, if, one, he and the mother are or have been married to each other, and the child was born during the marriage or within 300 days after the marriage ended. So the presumed father and the mother were married, and the child was married during the marriage or 300 days after the marriage ended. That's number one. 2, the presumed father, consent from the presumed father shall be required if before the birth of the child, he and the mother attempted to marry each other by a marriage solemnized in apparent compliance with the law, even though it could have been declared invalid. And the child was born during the attempted marriage or within 300 days after its termination. Or if the marriage was invalid without a court order, the child was born within 300 days after the termination of cohabitation. And 3, for the presumed father, consent shall be required if, after the child's birth, he and the mother have married or tried to marry each other, although it could be declared invalid, and with his knowledge or consent, he was named as the child's father on the birth certificate, or he is obligated to support the child pursuant to a written voluntary promise or agreement, or by court order. Or 4, the consent of the presumed father shall be required if he received the adoptee into his home and openly held out the adoptee as his child. So in those 4 cases, consent of a putative father shall be required before adoption can take place. And of course, that's not talking about, an agency adoption where termination, is where they seek termination. If they've gone through the termination route, then termination is acquired, and then they go through to adoption. But this is talking about an independent adoption where they seek consent first, and then go to the adoption. All right. So, transracial adoption can be a sticky subject, and it's in the past. In the United States, until the 1950s, a lot of states had laws prohibiting the placement of children across racial lines. And they were similar to the egregious laws that we had banning interracial marriages. Obviously, those gave us all black eyes. And, they were racist laws, and they all had the intent of maintaining white racial purity. But as courts began to strike down those nasty laws in the late 1950s, the laws, they were declared unconstitutional, and later, in places like where we live. But this constitutional direction was brought about, the constitutional direction was combined with other factors, social factors in the adoptive realm, and that included the increased number of children in the foster care system. So we had, we had to look beyond racial lines as far as adoptions go, because there was just a growing number of children of all colors in foster care, and there was a decline in the number of white infants available for adoption. And also, in our society, there was a growing number of interracial relationships. And also, there was, I think, there was an expanding mindset as far as social workers go. Um, I think I know this mindset was slower down in this where we live than it was probably in other places. Um, I know that when I started my practice in Decatur in mid 1990s, I represented a family who wanted to adopt their African American is a white family who wanted to adopt their African American foster child. And to just fill in the blanks for you, also is a medically fragile African American foster child. And so it would have been, and this was a fantastic home, and it would have been super for this child. But the Department of Human Resources would not approve of this because it was across racial lines. Well, first of all, they said that they wouldn't approve it because, back then anyway, they wouldn't approve it because they would not approve a foster home adopting their foster child. Then they said they would not, after we got over that hurdle, then they said they wouldn't approve of a white family adopting a black foster child. And when we delve into that, the concerns expressed by the social worker were concerns that this foster mother would not know how to address the specific concerns, needs, or concerns and needs, or concerns and needs specific to culture, and African American culture of this child. I remember like one comment she made to me was, how is she going to be able to do her hair? And my response was, I'm more concerned with her daily medical needs. And who else besides this person, this one woman, is willing to provide for this child's in medical needs in a loving way? I mean, this foster mother has already been doing it for 3 years and wants to do it for the rest of this child's life. But who exactly do you have waiting in the wings ready to do that other than this woman? Who else wants to do that? I mean, I felt like this particular social worker, was living pie in the sky here with me, whereas I had this foster mother who was ready to, had both feet on the ground, ready to adopt in real life a child with serious medical needs, and didn't, was, ready to address real concerns and real needs, yes, but cared more about the child, regardless of, race, culture, culture, ethnicity, whatever. She just wanted to love her. And I felt like the social worker was all caught up in her ideology. Um, so we got a court date set, and we were going to go and argue it before the court. And then we ended up going down to the court date, and then DHR just agreed. Once we got down to the very court date, and they just caved in and agreed. So that set the precedent in Morgan County, as far as I know. So in the beginning, it was sort of this, it was very much of it was a bias, an ethnic bias against allowing white families to adopt black children. But then, in 1972, we see the National Association of Black Social Workers issuing this opinion against the National Association of Black Social Workers, saying that white families shouldn't, that families should not be allowed to adopt across racial lines. Because they did not believe that white parents would be able to foster a healthy sense of racial identity and pride in their adopted children. But the problem with that is, what I felt like in my case in the 1990s, and that was we have a glut of, unfortunately, we have a glut of children in the child protective system who need homes, who need loving homes. And we have, even if we were to have an abundance of potential adoptive families, which we don't, but even if we were to have an abundance of adoptive families who want, whatever children they can get, which we don't, there would still be a backlog on terminating biological parents' rights. That takes time. And approving potential adoptive families, home studies, etc., that takes time. And then going through the adoption process, all that bureaucracy takes time. And so, meanwhile, these children aren't getting any younger. And the older they get, the more, let's face it, to a lot of families, the less desirable they get. A lot of families, they want the young kids. They want the younger children. So what we need to do is we need to open as many doors as we can. As if these families are willing and they are, positive and healthy families, we need to open doors. We need to make it a positive, easier process. We don't need to make it harder for them to adopt. So to address this problem with race in adoption, Congress in 1994 passed the Multi-Ethnic Placement Act and then amended it in 96 with the Inter-Ethnic Placement Provisions. And these two acts together prohibit agencies that get federal funds, which would include DHR, from considerations based on race, color, and national origin. And in there, it actually states that race, culture, or ethnicity may not be used as the basis for any denial of placement, nor may such factors be used as a reason to delay any foster or adoptive placement. So it's not just that they can't deny placement. They can't like say, got this black family or this white family, but let's see if we can't find a so and so family. You know, can't we can't just delay while we look for something else. We can't do that. Um, so um, so with the Multi-Ethnic Placement Act and the Interethnic Placement provisions, Congress made it clear that race can no longer be, race, culture, ethnicity can no longer be a factor in placement at all. There was there is just a little stopgap provision in case of, you know, just a particular circumstance in a case in which a particular occasion where race or ethnicity lawfully may be considered in a placement decision in a rare occasion it is allowed. But I mean, it would be just the offhand occasion. It would have to be a very rare situation. It does allow for that, but even though it doesn't allow, even though the Multi-Ethnic Placement Act doesn't allow for race, it does recognize the importance of developing a diverse pool of um, of prospective foster and adoptive placements. So it imposes a duty on state agencies to make a hardworking effort to recruit foster and adoptive parents who reflect the diversity, the racial and ethnic diversity of the children in their state. So, so state agencies who receive federal funding are under the Multi-Ethnic Placement Act are under a duty to recruit placement families, diverse placement families. Okay, I'm going to say just a final word about adoption abrogation and wrongful adoption. So, what about the case of buyer's remorse? By far the majority view is that children are not like a pair of pants. You know, when you buy a pair of pants at the store, you take them home, you put them on, and you're like, when I tried these on at the store, I thought they fit better than this. Maybe it was the lighting, but I thought they were a different color of yellow. I think I'm going to take these back. I'm just not going to wear them. Yeah, majority view by far, we can't do that with children. We can't take them home. We can't go through this elaborate process and then, you know, and then approval by the court and then take them home and then decide, just not working out. I think I'm going to take them back. No. And why is that? Is it because, you know, why is that not good? Is it because it's not good for the child? Children who are adopted are already originally uprooted. They are uprooted from their family of origin. And this is based on no choice of their own. Um, During my practice of law, I took off several years in the middle, and I worked for a while at a place called Three Springs. And I worked with teenage girls who had emotional and behavioral problems, and it was at a residential treatment facility. And at this residential treatment facility, their parents would choose to place their teenage girls there for a period of, up to a year or a year and a half for treatment, and they would live there during their treatment. And so you can imagine. In order to send your teenager to live in a place away from you, some people live in California and they would send their kid to Alabama for this treatment facility. Some people lived in New York and they would send their kid to this treatment facility. So, and you can imagine to send your kid that far away from home for a year and a half. And this is, we're talking about some pretty serious issues. I remember not long after I was there sitting down with one of the files and just suddenly realizing that 75% of my group of 25 kids were adopted. No, not 25 kids, sorry. 75% of my 50 kids were adopted. Sorry. I just didn't think that was just coincidence. And so, starting at that point, I always talked to them about that. And, some of the things that they talked about were that, no matter what additional issues, and this wasn't all of them, but some of them talked about that no matter what additional issues, mental health issues that they had that they worked on, that the fact that they had been given up by their birth mother, or the fact that they were separated from their birth father, what was always an issue. Was always an issue to be addressed. And that it was just an ongoing issue, that separation, that uprootedness. And I think that when we fail to address that as a society, as an agency, as an adoptive family, especially as an adoptive family, I think when we fail to address that, I think that we make a big mistake. When we say, okay, well, now you're adopted and you're a part of our family, so there you go. No, I don't think it works that way. So, when we talk about adoption abrogation, once an adoption is final, it's final. And when I do an adoption, and when I'm appointed as the guardian ad litem for a child in an adoption, when an adoptive parent files to adopt a child, and the court appoints me as the child's guardian ad litem for purposes of the adoption, and we have the hearing, I always ask the adult who's seeking to adopt the child, do you know that if you're allowed to adopt this child, you're going to be no different than as if you had this child yourself biologically. They're going to inherit from you as if they were your biological child. You're going to be responsible for providing from them from that day forward. You're going to be responsible for disciplining them, for providing for them in any and every way that any other kind of biological parent would. No going back. Some states recognize something called wrongful adoption. I found a case, I looked it up on Lexis, and I found a case it was a federal case. It had been appealed to federal court from Georgia. And in that case, there was a couple that said that an adoption agency had lied to them and said that a child was free of mental and physical harm. Children were free of mental and physical harm, children that they were seeking to adopt, when in fact there had been mental or physical harm to these children. And so they were seeking to recover on the tort or civil injury of wrongful adoption, civil theory of wrongful adoption. And they were seeking to recover. They weren't seeking to undo the adoption. They were seeking damages on the theory of wrongful adoption. I believe I could probably stomach that a little more than I could seeking to undo an adoption. But there again, you're still putting out to the world and also in front of your adopted children that there's something wrong with their adoption. And, adopted kids are sensitive. I'm not speaking for every single one of them, but I've known a whole bunch of them. And, they're a lot of them are kind of sensitive about their adoption. And, the ones that I've known that have been really successful, the way that the adoptive parents have approached it is that once they're adopted, they're just like their own kids. And we just don't, yes, we can talk about it, but we just, we don't keep talking about them, being, my adopted kids, So I don't know about them going out there in a court action talking about being wrongfully adopted. So I don't know about the public policy behind that, allowing people to sue on the basis of wrongful adoption. I don't know if that's good for the kids or not. And I could not find an Alabama case. It's in the federal circuit that includes Alabama, but it is not an Alabama case. It is a Georgia case. So there was no case specific to Alabama. So that is adoption in Alabama. All right, so I'm going to post your test on Monday, the Monday the 4th at 5:30. And it will be active until 8. And then your family law project will be due on the 8th. If you have any questions, let me know. As usual, I'm open. And if for some reason you don't get the answer by the time you need it, you can always call me. I'm in my office every day, so still. So you can always call me, and I'm available. And I will post this lecture to the link on course content and in the lecture tab. And if you have any questions, just let me know. I hope you have a good day, and I look forward to getting your projects. Good luck on your test.